Bob Scully's World Show is made possible in part by GDI, Commercial Cleaning Services, one provider, one solution. And by Clocks Technologies. Biophotonic lighting manages skin from within.
Hi, this is Bob Scully, and welcome to another edition of the World Show, the Free Markets series. Free markets and the rule of law intersect throughout American history, even though they're quite different. And no one can explain that better and count the ways with us than Justice Douglas Ginsburg, who is the senior circuit judge on the United States D.C. Court of Appeals. He's quite the historian in his own right, as you will discover. Here he is. Justice Ginsburg, welcome to Free Markets, and the series I mean, not the reality. And we've been asked to look into something with you, which is the intersection, to use a fashionable term, the intersection between the world of law and the world of free markets. And in fact, one of the mainstays of the American Republic and one of the things that makes it so admired around the world is rule of law. And it's generally agreed that from the inception of the Republic in the 18th century to today, it's been maintained. But where does it stand?
Well, it's been maintained, but eroded a bit. We still have primarily a common law system, and that has stood us in good stead with respect to commercial matters. But there have been some divergences, some exceptions when one wonders whether a particular court or body really understands the importance of the rule of law. But I'd say relative to the rest of the world, we're in good shape, and that's why capital keeps coming here.
And why can't other countries imitate it? That's the other thing. The exceptionalism of it is impressive, but worrisome. It means that other countries that say they have it don't really have it.
Well, it's a matter of degree, of course, but I think one feels pretty secure in the United Kingdom and Canada, in Singapore and Japan and Germany. I mean, it's not a matter of critical collapse in any of those places or several others. There are, of course, places around the world that have really lost hold of the rule of law or that never had it.
And that don't correct for it. There has to be something to correct it.
Well, if the problem is corruption, the corrective is essentially unknown. I'm not sure there's any jurisdiction that has gone from having a corrupt judiciary, for instance, to having a non-corrupt judiciary in anything like a reasonable period of time. It's very difficult to correct that.
And another thing that stuns countries around the world is the way a single judge sitting somewhere, and I like that. I find it impressive personally. A single judge sitting somewhere in a rural jurisdiction brings the enormous machinery of the U.S. government to a halt. And I think in your career you've done some of that.
Well, there's been a development in just the last several years, perhaps 7 or 8 years, in which a single judge, federal judge, sitting somewhere, chosen for this very purpose, issues an injunction against the government in some program and purports to bind the government not just in that judge's jurisdiction, but throughout the country. And the propriety of that is I think, very doubtful. It's inconsistent with the regional structure of our court system, in which it's expected that there may be differences from one circuit to another across the country, and when those arise, the Supreme Court has to resolve the conflict. There can't be a conflict if one judge can rule for the entire country. Now, some matters are inherently nationwide. I mean, there's no way to enjoin something only in a certain jurisdiction, but for the most part, it could be limited to that particular jurisdiction, and always was until very recent times. The government has argued the point in the Supreme Court at least once but the court didn't reach it. This is in the last couple of years. Didn't need to reach that point because it was reversing the ruling on its merits. But it will be only a matter of time before I think the Supreme Court will put a stop to that practice.
And did the founders intend, I kind of like the flexibility as you describe it, when there is disagreement in the country, it's because there's disagreement in the society. And to have that expressed differently by different courts in different regions sounds okay to me at first anyway. And of course it has to be reconciled. But did the founders envision that, or is this kind of a sort of a sui generis consequence that even they couldn't foresee in the 18th century?
Well, the original, the Constitution itself, I should say, provides only for the establishment of a Supreme Court. And it says, and such other inferior courts as the Congress may from time to time create. And so there was no way to contemplate a distributed system like this because there was no occasion for it. Now, they realized that the Congress would in fact create lower courts, and it did. But the justices of the Supreme Court rode the circuit. They went around the then rather small country and participated in reviewing the rulings of the trial courts.
On horseback, too.
Well, riding circuit, I gather, had to be on horseback, and eventually your carriages, I suppose. But as the country grew, the Congress divided it into now 12 geographical circuits. And each of the first 11, circuits 1 through 11, all encompass more than one of the states.
Yes.
And the D.C. Circuit encompasses only the District of Columbia.
A bit like the Fed. A bit like the money.
In that there's a Federal Reserve system with regional banks, and then there is the Federal Reserve Board in Washington.
But the conflicts, as you say, could only happen as time went by and they appeared of themselves.
Yes, and most of what the Supreme Court does, if you look at the caseload that it has, is resolve conflicts of that sort. Whether about a statutory interpretation or a constitutional issue.
And when a judge is about to issue, you've done this, a ballsy decision, as they say, a blockbuster decision that will rock the system and get the press all excited and so on. How does that happen? I just want to lift the veil a bit and take the curtain back. Do you go through a lot of anguish and how am I going to say this? And do you talk to colleagues and they try to prepare you and say, watch out, you're going to get hit by an editorial in the New York Times or whatever? How does that happen?
Well, on a court of appeals, we sit in panels of 3. And so the product is institutional. The decision is a written decision subscribed by at least 2 of the 3, usually all 3, more than 90-some% of the time. And it's very, very carefully drafted so as not to address questions that needn't be addressed or resolve matters that needn't be resolved, to be as clear as possible. I have gone through as many as 32 drafts of an opinion before issuing it.
Holy cow.
And in the course of that, sent 2 memoranda to my colleagues, the other 2 on the particular case, which went through many drafts, and got their input before we had a product that we were all pleased with.
And when the case is important because ideology is involved, and you get a classic right-left, Republican, Democrat opposition, and you are one of them on one side, and everybody knows that, and your 2 colleagues or one of them is on the other side, you guys go to conference, as you say. Does all hell break loose when the door is closed?
I first of all, I can't remember a single case in 33 years, in which a voice was raised at conference. Wow. The longest conference I've ever had, 2.5 hours on one case, was with Judges Bork and Mikva. Polar opposites from the way you just described them. And the 3 of us spent 2.5 hours trying to save a judgment from the district court in a very complex drug conspiracy case. And we were unable to do it, and we had to reverse that conviction. There was some ambiguity in what had occurred, and we were hoping that we wouldn't have to start the process all over again. But struggled as we did as a team, we were unable to do that, and we had to reverse the conviction. Now, let me go back to the premise that you're talking about Republican and Democrat. When the court divides, and when it divides along what are fairly described that way, it's not because of ideology, as you were implying. Or at least I wouldn't call it that. It's almost always because what the court has been tasked to do is to decide whether something that the executive has done, that the legislature has done, is reasonable. That's the term that typically...
Yeah, the classic term.
That typically causes people to differ. And if they differ along what appear to be partisan lines, it's really the partisanship of the appointing presidents, not of the judges. Mm-hmm. That's because what appears to be reasonable does differ between, let's say, conservative people and what is now called liberals. Mm-hmm. I mean, classical liberals are more like conservatives. So that reflects, I don't think ideology, reflects their life experience and what they brought to the court when they came to the notice of the president and were nominated. So when it's not a term like that that's so open-ended, such as reasonable, you get very little difference among the judges. As I said, more than 90% of our cases are unanimous. If we ask, well, what about how many, when I say unanimous, I mean one opinion for 3 judges. If you throw in the ones where the separate opinion is concurring, mm-hmm. maybe expressing it differently or raising some concern, it's more like about 97%. Oh, that's
pretty...
in my court.
That'll get you through high school.
Yeah.
and what I find reassuring there is when we look at the degradation in the political realm, in the legislative branch, how the chasm developed between the two ideologies until they became, not on speaking terms. That happened through an excessive expression of opinion and fortified and done over and over, and it just grew as a chasm. That's not happening in the judicial branch then.
When a judge takes office in our federal system, he's not been elected. Many of the states have partisan elections, or many of them elections, and most of those are partisan, not all. So the judge hasn't been elected, doesn't retain any sort of party affiliation in the sense of having to run again. It's a lifetime appointment mm-hmm. with a guarantee of salary. There's nothing to fear, no one to fear. Not the New York Times, not the appointing president. Important. And many a president's been disappointed.
With their own nominees.
Absolutely. Yeah. Sure. It takes about a very short period of time after hearing the first case to realize I don't have a dog in this race.
And to call the judges, to imagine what they're going to say is very perilous. People say, this guy's going to be for it, this one's going to be against it.
For the most part. The Supreme Court, perhaps less so, but in the lower courts, that would be particularly perilous. There are exceptions. There's a judge who died just a couple of years ago who was notoriously indifferent to being reversed by the Supreme Court. Mm-hmm. Once said they can't catch me every time. That's really inconsistent with the rule of law. Really inconsistent with the rule of law. And an exception of real note because it's so rare.
Of course. And occasionally you'll get, I suppose, your political past catches up to you, like Abe Fortas in the days of Lyndon Johnson. I don't recall exactly how it turned out, but wasn't he named and had to go?
He was appointed to the court. He sat for a short time, a couple of years perhaps. But it came out that he continued to provide some advice to the president.
Okay.
And if I recall correctly, he also was paid for some speeches he gave, I think, in Las Vegas in a way that was inappropriate, let's say, and so resigned.
But those are the exceptions.
Oh, yes.
And I remember attending a discussion once on Montesquieu, L'Esprit des Lois, the famous division of the three branches, where it all came from that book, and asking a specialist, well, all right, of those 3 branches, in the end, which one runs the show? And of course, the stock answer is, well, none of them do. They all check and balance each other. But if you pressed that guy, he said, but the judges have the final say, not the politicians and not the functionaries. What do you say?
The judges have the final say only with respect to constitutional issues, which are about a quarter of what the Supreme Court does, by the way. And the finality of their decisions was not really established until the latter half of the 20th century. In Justice Breyer's book, I forget which one, but the one most next to most recent, he basically says he thinks that that President Eisenhower showed that he was a great man when he enforced the school decrees. He got conflicting advice. The Attorney General advised him that he should enforce the school decrees that coming out of the Brown decision, and political advisors advised him not to do so. It was still an open question at that point, 1954.
He sided with the rule of law.
He did. He did. I've lost the thread of what you were saying earlier, but
well, we're discussing is
about
any branch more.
The framers were quite clear that with their concern that the legislature would be dominant if not constrained. This was, of course, true with Parliament. Parliament,
yeah, of course,
sovereignty and supremacy, and they didn't want to have any one branch be supreme. But that structure has been severely compromised in the last century.
Why?
The legislature has successfully delegated legislative power to executive agencies and to the president time and time again. And until 1935, that's the last time the Supreme Court said this was an unconstitutional delegation of legislative authority. Since then, they've said, well, if there's an intelligible principle for the executive to follow, then the delegation is lawful. And they've said delegation to act, quote, in the public interest, close quote, is an intelligible principle. So basically, the Congress has been able to delegate authority for very momentous decisions to executive agencies like the Environmental Protection Agency or the bank regulators, and to the president, as example with the tariffs that we now have. I mean, under the Tariff Act, the president has the authority to do a great deal to affect the economy, and President Nixon did it. He suspended the gold convertibility. He imposed wage and price controls during peacetime. Well, there was the Vietnam War, but I mean, the economy didn't really require wage and price controls for a short time, but that was delegated authority. When the Iran deal came up a few years ago, it wasn't submitted to the Senate as a treaty for ratification by 2/3. And you didn't hear senators saying, wait a minute, bring that into the Senate. Let us take a look at it and either approve it or not.
Right.
They're very happy to delegate authority because then they're not responsible.
That's it, they're not held for it.
Yeah, they're not responsible. And they can vote for something like clean air. Let's have clean air. EPA, you give us clean air. And then when EPA makes decisions that affect hundreds of billions of dollars over a period of years, the affected parties can write to their congressman and say, get me some relief from the EPA, and the congressman will write a letter to the EPA or what have you, and then take credit for that.
But that's democracy too.
It's hypocrisy.
Well, yes, but it's
but anyway, it
willy-nilly.
erodes the structure. Right? It means that the Congress has willingly turned over much of its authority to the executive, and that was not something that could have been anticipated. Quite the contrary. Madison thought, when he said that faction would constrain factions, that each of the branches would be jealous to conserve and maybe expand their power, not happy to give it away.
A logical conclusion.
Yeah, one would think so.
Yeah.
One would think so.
Didn't happen.
But they also didn't anticipate political parties, which are factions, as they use the term. So things started to change quickly, or soon after the Constitution was ratified, but not to such a drastic degree until the last 80 years or so.
And never to really imperil rule of law.
No, I think that's right. I mean, it's pretty high-handed to let the president impose wage and price controls, but it was consistent with the law.
And to get back to free markets, reading some of the recent research, one thing that stunned me is that what we call progressive is in fact maybe not that progressive. I mean, the encouragement of certain social initiatives, the growth of huge conglomerates that are unopposed. Where are we headed with that? Are free markets still thriving?
Our economy is doing great.
Yes, absolutely.
I think most of it is highly competitive. There are sectors that are less so. Consumer prices are stable. Inflation is, the Federal Reserve would like to have more inflation than there is. So I think the competition is working very well throughout the economy. Again, there are always exceptions, have been from the beginning.
So it's kind of a bogus issue.
Well, I'm not sure what the issue really is. I mean, to say...
Well, Google, Amazon, et cetera, people are beginning to fear that, and then they're turning into scarecrows.
Well, it's been clear for a long time that size is not an offense.
Doing badly is an offense.
Becoming big by suppressing competitors or deceiving consumers is an offense. But size itself is no offense. President Taft said that in those words.
After Teddy Roosevelt.
Yes, but Taft brought twice as many cases as Roosevelt in half the time.
Oh.
Antitrust cases, but never based on size alone, always based on some sort of conduct. And that remains the state of the law, even now.
And preferable to, so Teddy Roosevelt kind of took the sledgehammer to malefactors of great wealth, as he called them.
Right.
But there are some people in the political spectrum who'd like that to happen again.
There probably always have been. You're just hearing more of it now. People are, some people are always going to be afraid just of large companies, large institutions. If they got large by serving consumers well, more power to them, and more money, as it turns out, too.
And so in the end, it is a boogeyman. We're worried about nothing.
Well, we don't know. There are investigations going on among the states, collaborating at the FTC and at the Department of Justice Antitrust Division, inquiring into exactly these questions. Did these companies become so large by suppressing competition or deceiving consumers? We don't know the answer to that yet.
And I don't want to let this opportunity go by and pick your brain and your wisdom on a cliche that keeps coming up. I've spouted it many times, and when I think of it, I'm not sure what I'm saying, that America is over-litigated, over-lawyered, spends too much money. And in the cliche is the classic comparison between Japan, which has a minimum, it seems, of lawyers and litigation, and America, which has tons of it. And therefore, people say we're wasting, part of the economy on just paper shuffling. Is that true?
There are about 100 million legal matters initiated every year, but that includes traffic offenses and that go to court, and divorces and custody and all of those things. And a very, very small percentage of them ever go to trial. So they are a way for parties to negotiate and threaten and go through a kabuki dance, as in Japan. But what gets to court is really a very tiny portion of that. What we define as lawyers' work is different from one country to another. In many countries, so-called notaries do a lot of things that we have lawyers do. It doesn't mean that they don't get done or that they're done even in a different way. That's just a categorical difference.
Yes.
But there are real differences. I mean, we are more litigious than Canada, obviously. I'm here right next door neighbor. We have more in common with Canada than perhaps any other country, and this is a big contrast. So
true. So would it be wise to try to diminish that, and could it be done?
Well, if harmony were to break out in the land, then there would be fewer disputes and less litigation.
In other words, it's a consequence of other things, and those other things aren't changing.
It's a large country, a large population with conflicting interests everywhere, and this seems to be a reasonably good way of resolving disputes.
So the old cliche, about the Susumi, the sushi restaurant in Beverly Hills.
No, I don't know.
Susumi. Never heard that?
No.
so the idea that it's complacent and everybody does it practically for fun is not a fair idea.
Well, California used to have a litigation problem, I think, but they've on medical malpractice, they've capped non-economic damages. That made a big difference in that category. They've now require that a person bringing an action under Section 5 of their Consumer Protection Law actually have been injured, have standing to bring the suit. That's reduced it a lot. So when things get out of hand, typically the states or the Congress do rein it in. I'll tell you, class actions are another example.
Yes, absolutely.
There was a lot of abuse,
Yes,
and
true.
then the Congress passed the Class Action Fairness Act and brought it to heel. Same thing with the securities laws.
Well, I'll tell my friends, when things get out of hand, you want to go before Justice Ginsburg and use my name. So thank you so much, sir.
Thanks for having me here.
Justice Douglas Ginsburg was our guest this week on the Free Markets series of The World Show. I'm Bob Scully. Have a great week. Thanks.
Bob Scully's World Show was made possible in part by GDI, commercial cleaning services, one provider, one solution. And by Clocks Technologies, biophotonic lighting, manages skin from within.